What happens to buyers when their property developer goes bankrupt? This has recently been an issue with the Ralan property group, which seems to have gone under. Now we'll see what might happen to buyers in this situation and whether and under what circumstances they might be able to get their money back. And the short version is these buyers are in a very precarious situation. We need to categorize buyers into several different types. The first buyers, which are the safest, are those buyers who have paid their deposit to buy their unit and that deposit money has been kept in a separate trust account. Typically, you will need to pay a deposit to buy a unit, so it would be very unlikely that any of these buyers won't have paid a deposit. So for this first category, they've paid the deposit, it's been kept in a separate trust account. In this situation, the buyer's money is still the property of the buyers. It's in a separate trust account, the property developer hasn't touched it and hasn't legally been allowed to touch it. In this case, the buyers can get their money back and they're probably in the best situation. They might try to sue for loss of bargain damages. So for example, if the apartment would have increased in value, they can try to sue for the loss of that increase, but that would be extremely difficult to get off the ground, typically because the property developer doesn't have any money left, so you won't really be able to sue them for anything. So probably they'll get the deposit back, but probably that's about it. The second category is those who have put their money into a trust account and then the property developer has taken the money from the trust account illegally. In that case, the money is still gone and they'll need to go through legal courses of action to get the money back. That would involve suing the developer and probably suing the lawyer that allowed them to take the money out of the trust account. Now, typically the developer won't have any money left, so in broad terms you won't get much money from them, but in that case the buyers will basically be able to claim their money back because they've taken the highest priority in the event of bankruptcy because the property developer in that case has effectively stolen their money. They could also sue the lawyer for enabling that breach, because that would be a breach of the lawyer's professional duties if they've allowed the developer to take the money out of the trust account. So that would be the second situation, and those ones are relatively safer than some other buyers, but obviously not as safe as the first category. The next category we really have here is the ones where the buyers have put their money across to the developer as a deposit, and then they've allowed the developer to use that money. So they've allowed the money to not be put into a trust account, but to be put toward the uses of the developer. That could be construction expenses or myriad other expenses. In that case, those buyers are in a very precarious situation because the money is no longer theirs per se. It's kind of gone to the developer for their use and expenses. Those buyers are now effectively unsecured creditors in the most part. What that effectively means is in the event of bankruptcy, secured creditors will get their money back first, unsecured creditors will get it back later. To think about that in lay terms, when you have a mortgage, the bank will get your house first and then other creditors will be able to get money later after you've got a bankruptcy. So in the event of the developer, the bank will be able to claim assets before any of these buyers. So for those people who have given their money across to the developer and enabled the developer to use the money for expenses, they're in a precarious situation. For people to know exactly which situation they're in, they would have needed to consult with their solicitor at the time of the purchase. The solicitor will normally have advised them about the particular characteristics of their contract, whether the money will be kept in trust or whether it will be used for the developer's expenses. A good solicitor would typically advise an individual to not enable the developer to use the money for expenses unless there's compelling reasons to do so, because obviously that creates a risk. So if we look at these three categories, some of these buyers are going to be in a very dubious situation where they might not be able to get their money back. But some buyers who have insisted on their money being kept in a trust account and the money has in fact not been touched will likely be able to get all of their money back. So really the situation of the buyer depends on the exact nature of their contract and what happened to the money. So I hope this has given you some insight into what happens when the developer goes under, what happens to the buyers in terms of their deposit, and which buyers are likely to be able to get their money back. I hope the video has been interesting to you. If it has, it would be great if you click the like and subscribe buttons, and I hope to see you next time. Bye.